Assalamualaikum warahmatullahi wabarakatuh to our respected lecturer, Sir Muhammad Hafiz bin Shahri. Today, my group will be presenting question 1s, which are meetings, member resolutions, and members' right in Malaysia.
So, my name is HAZIRAH binti ARZAHAR.
My name is FARHANNA IMAN bin AFFANDI.
My name is RAFIQAH binti MOHAMAD ARIFFIN.
So, this is the situation given that should be applied. Today, I'll walk us through the legal framework that governs Extraordinary General Meetings or EGM under Malaysia's Companies Act 2016. Imagine this, you are a shareholder in a company and one morning you receive an urgent notice. The company is making a major change to its constitution. No prior warning and it's not AGM season. What's going on? This is where the EGM steps in. An EGM is a vital mechanism in corporate governance designed to handle urgent or significant matters that can't wait for the next annual general meeting. It allows important decisions to be made quickly, but it also raises crucial questions about how these meetings are called, what rights shareholders have, and how dissent is managed within the legal framework. Let's explore how EGMs operate, the legal requirements behind them, and what protections exist for the shareholders, especially when decisions are contested. So the first part is the legal requirements convening an EGM. We'll focus on 3 key legal requirements that must be fulfilled for an EGM to be properly convened under Malaysia's Companies Act 2016. Namely, who can call the meeting, how notice is given, and the quorum needed for it to proceed. So who can convene an EGM? There are 4 authorities that may legally convene an EGM under the Companies Act 2016. The first is the Board of Directors or BOD under Section 310A. This section allows the board to call an EGM at any time, especially when urgent or important business arises. In the case of XYZ Sdn Bhd, the board relied on this provision to call the meeting in order to propose a significant change to the company's constitution. The second is any single member under Section 310B. Although this route is rarely used, it allows an individual shareholder to convene an EGM independently. However, this doesn't apply in XYZ's case as the EGM was not initiated by any single shareholder. The third authority comes from the members themselves under Section 311. If shareholders holding 10% or more of the total voting capital make a formal written request, the directors are legally obligated to convene an EGM. In XYZ situation, if the shareholders opposing the proposed constitutional change meet this 10% threshold, they can request a new meeting to challenge or reverse the board's decisions. The fourth is through the court, as provided under Section 314. If directors fail to act on a valid member request under Section 311, the dissatisfied shareholders may apply to the court, which can then order the company to convene an EGM. This acts as a legal safeguard when directors refuse to engage with shareholders' consent. These 4 authorities ensure that the power to convene an EGM is not concentrated solely in the hands of the board. It also provides mechanisms for shareholders and ultimately the court to play an active role in corporate decision making. Under Section 316 of the Companies Act 2016, a company must provide a notice with a minimum of 14 days notice before holding an EGM. If the company's constitution sets a longer notice period, for example 21 days, then that longer duration must be followed. The purpose of this requirement is to ensure that all members have sufficient time to review the agenda, seek advice if needed, and appoint a proxy if they are unable to attend. In the case of XYZ Sdn Bhd, if the board failed to meet this minimum notice requirement, any resolutions passed during the EGM could be challenged and potentially declared invalid, especially by shareholders who oppose the proposed changes. And the last one, under Section 328, the quorum requirements. An EGM requires a minimum of 2 members to be present either in person or by proxy unless the company's constitution specifies a higher quorum. If the quorum is not met within 13 minutes from the scheduled start time, the meeting must be adjourned to a later date. No business or voting can legally proceed until the minimum attendance is satisfied. In the context of XYZ Sdn Bhd, this requirement plays a key role. If the shareholders who oppose the constitutional amendments decided to walk out or boycott the meeting in an attempt to prevent quorum, the company would be forced to adjourn the EGM. This protects against important decisions being made by only a small, unrepresentative group and ensures that any resolution passed reflects the participations of a valid number of members. Failing to meet quorum makes the entire meeting procedurally invalid. That's all from me.
Next, I will be explaining the role of members' resolutions in the context of company law in Malaysia using XYZ Sdn Bhd, a private limited company. Okay, so XYZ Sdn Bhd has called for an extraordinary general meeting or EGM to propose a major change to its company constitutions. But here's the twist, not all shareholders agree. Some are even strongly against the proposal. So the big question is, can the company still go ahead with the change? Well, that depends on two main things: the type of resolution being used and whether the proper legal process is followed. Next. So first, let's define what a member's resolution actually is. A member's resolution is a formal decision made by shareholders when they vote on a proposal during meetings such as the EGM. This is one of the main ways shareholders can influence company decisions, especially for major or sensitive matters. Under the Company Act 2016, there are two main types. First, ordinary resolutions under Section 291 requires a simple majority, just over 50% of the votes. For example, if 6 out of 10 shareholders vote yes, then the resolution passes. This is typically used for routine matters such as appointing directors or approving dividends. Second, special resolution under Section 292 requires a supermajority of at least 75% of the shareholders present and voting. Must also be given with at least 21 days notice, and that notice must include a statement that a special resolution is proposed, the exact wording of the resolution. This is reserved for serious changes such as amending the company's constitution or reducing share capital. Okay, next. Now, let's apply this to XYZ Sdn Bhd. Since the company wants to amend its constitution, it must use a special resolution under Section 292. This means two things must happen. First, at least 75% of shareholders who attend and vote at the EGM must support the resolution. Second, the company must give a clear 21-day notice before the meeting, clearly stating the intention to propose a special resolution and including the exact wording. If this supermajority threshold is not met, the resolution fails and the constitution cannot be changed. Okay, next. Why is this legal process so important? First, it protects shareholder rights, ensuring that no major changes happen without strong support. Second, it guarantees transparency and fairness in how the company makes decisions. Third, and importantly, it prevents abuse of power, whether by the board or a simple majority. Okay, so what happens if the special resolution is passed properly? First, the resolution becomes legally binding on the company, including the director. Second, the company must then submit it to the Companies Commission of Malaysia, which is SSM, within 30 days. So, let's look at a real Malaysian case, which is Regenetech Technology Berhad. So, the fact is Genetech held an EGM to amend its constitution and issue new shares. Some minority shareholders challenged it, claiming the notice was unclear and the 75% vote requirement wasn't met. So the issue is whether the special resolution valid and did the company follow proper procedure. So the court held, yes, the court confirmed that the resolution was valid because first, proper 21-day notice was given. Second, the resolution wording was clear and over 75% voted in favor. So the conclusion, the company lawfully amended its constitution and the resolution was binding. That's all.
Alright, so next I will be explain about the focuses on the right of dissenting shareholders under Companies Act 2016. So dissenting shareholders are those who disagree with a resolution proposed at a company meeting, especially during decision like changing the constitution. Although their views may not prevail, the Company Acts provide them with legal protection. In this presentation, I will explain two important rights, which is the right operation remedies under Section 346 and derivative action under Section 210. So, first, Section 346 of Company Act 2016, which is known as the operation remedies. Section 346 protects shareholders, especially the minority shareholders, from being treated in an oppressive, unfairly prejudicial, or discriminatory manners by those in control of the company. So it means if the majority use their power to make decisions that hurt or ignore the minority, the affected shareholder can ask the court to step in. So the court can do many things to help, such as first, cancel or change the company decision. Second, order the company or majority to buy the minority shares. third, give instruction on how the company should be run, or lastly, or even remove or appoint the new director. So the application from the case scenario involving XYZ Syndrome Berhad, the company is proposing a major change to its constitutions. If this change unfairly remove or limits the right of minority shareholders, they may seek court relief under Section 346. The court may then cancel the resolution under a buyout of their shares or regulate the company's conduct. So, as the case reference of RAFIQAH Mills Syndrome Berhad, so in this case, the minority shareholders claim that the company affair were being conducted in a way that was oppressive and unfair to him. So the majority shareholders who were also director used their position to control the company unfairly, exclude the minority shareholder from management decision, run the businesses in a manner that only benefit themselves. So the court agreed with the minority shareholders and rules that the conduct of the majority was oppressive. It ordered a remedy under the operation provisions. So which is it include the buyout of the minority shares to give him a fair exit from the company. So in short, Section 346 it can help shareholders who are treated unfairly, and it allowed the court to give a fair solutions. So the second, Section 210 of the Company Act 2016, which gives shareholder the right to bring a derivative actions. That is to take legal action on behalf of the company. So this usually happen when the people in control of the company, such as the director or majority shareholder, are doing something wrong, but the company itself refuse to act. Some example of this wrongdoing include the breach of duty, misuse of power, or dishonest or unlawful conducts. So Section 210 allow any shareholders, including a dissenting minority shareholder, to apply to the court for permission to sue wrongdoing in the name of the company. So this is the way to hold director or insider accountable when the company on management fail to do so. So applying to the case of XYZ Syndrome Berhad, if the director or majority shareholder are using the process of amending the constitution to give themselves unfair benefit, bypass proper procedure, or act against the best interest of the company, then the descending shareholders may apply to the court under Section 210 to challenge their actions. Okay, so the case reference of this section in the case of Ng Kek Wee versus SimCity Technology Syndrome Berhad. So in this case, the shareholder, which is the Ng Kek Wee, found out that the company directors were acting wrongly and harming the company's financial interest. However, the company itself refused to take any legal action against the director because they were in control. So as the result, the shareholder applied to court to bring derivative action, that is to sue on behalf of the company, not in his personal capacity. So the court allowed the derivative action to proceed because of there was strong evidence of wrongdoing by the director. The company was under their control that will not take action on its own. So Section 210 is a powerful protection for shareholder. It ensures that even if the majority refuse to act, minority shareholder can still stand up for what is right by taking legal action in the company names. So lastly, as the conclusion from this case of XYZ Syndrome Berhad, it highlights how the Company Act 2016 played a crucial role in regulating corporate governance through clear procedure, especially when major decisions like changing a company constitution are involved. So from the legal requirement for convenience and EGM to the type of resolution and the right of dissenting shareholder, every step is designed to ensure fairness, transparency, and accountability within the company. So the board has the power to call for an EGM, but shareholders also have significant right, whether it's to request their own meeting, challenge improper decision, or seek court intervention if their interests are oppressive or ignored. Ultimately, this legal framework provides balance between majority rules and minority protections, allowing company to function efficiently while still respecting the voice of all the members. So that is from us. Thank you.